Well, welcome today. Scott Thomas with Stewardship Matters here with Wayne Becker. I had done a little survey this last year, back in 2021, and the number one thing that actually showed up in my client survey was that people wanted to know more about estate planning. And not just estate planning basics, but some more advanced types of estate planning. The second item they wanted to know more about was income taxes and maybe what the new debts and some of the changes with the new administration are going to look like as well. We'll do that in the future. So I'm a financial advisor. I'm an independent fee financial advisor. My company's called Stewardship Matters, a little boutique, Maitland, Florida. Been working with Wayne Becker, my friend, my colleague. I view Wayne as a trusted resource. And what I love about Wayne is he has two ears. Well, what do I mean by that? Wayne has two ears because he actually listens. He actually hears what clients want, what people want. When they come in and talk with Wayne, he listens, but he also has specialization. He has things that are just wonderful. He listens to make sure that there's clarity in the conversation both ways. A lot of times people are scared to have a conversation around trust. They go, it costs too much. I don't really want to go and sit down and talk with someone. One of the reasons why I'm doing the webinar today is I want there to be some education about the various types of trust, truth about trust, some of the misunderstandings about trust, where they get messed up, where they get derailed. And so right now I'd like to ask Wayne Becker to give us a short shout out on your practice, what you do, Wayne, and then we'll jump right into the trust.
All right, Scott. Well, thank you. Thank you for that wonderful introduction and, the confidence and the things that we build up over the years, I think have really helped our clients as we've worked with them together. So it's really a wonderful opportunity for me to continue to do that work and to spread it to more people who might also be benefited from what it is that we do. As you all might see, I have a few grays up here, so I've been at this for a while. I actually qualified for the bar about 35 years or so ago, but I have been specializing in estate planning over the last 15 years, and 12 of those years in my own firm. I really enjoy the ability to make my own calls with regard to dealing with clients, because as many of you know who do engage attorneys for other things, there's this thing called hourly billing. And quite honestly, hourly billing and estate planning really don't go very well together. You have to take the time, and I'm glad that Scott pointed out the fact that we do sit with our clients, we listen to them, and we receive phone calls, and we all know that little bugaboo getting that call, the bill for the 15-minute phone call. That's not the way we do things here, because you really can't do this well unless you listen. Because as I mentioned when we were kind of doing our build up to getting this call going today, it really is incumbent on us to listen, because we have to operate within a certain amount of bounds, but at the same time, we need to customize the documents in a way that make them sensible to each and every client. So with that as background, as I said, I've been at this, and this is solely what I do. I know a lot of attorneys will do estate planning off the back of their other practices, but that's not what I do. I do just solely this type of work so I can stay as educated and up to date on all the newest things. And we're going to talk a bit about those as the seminar goes on today. But man can't work by just work alone. So I just wanted you to know that I'm an avid golfer. I get out every time I can. And I also love to travel. As Scott knows, I try to sneak away in the summer when it gets a little warm here. I've been focusing my attention most recently on summers in Portugal. So if anybody wants any more information on that, you can send me questions about that as well. But anyway, very, very happy to be with you all, and look forward to answering your questions and giving you some more insights.
So I'm actually curious about expatriation and conversations about when you go to other countries. And I'd like to also connect you up with the immigration attorney who's really good at where you come from other countries to get your citizenship here. I'd love to do that as well. So I was talking to a professor friend of mine. He teaches law, and he said there's 35 trusts that he's identified. We're not covering 35 trusts today, I promise you, because even the EPA cleanup super fund is a trust. We're not covering anything like that, but we're going to cover some trusts that are very germane, very mainstream. And so one of the first questions that always comes up says, do I have a revocable trust or an irrevocable trust? How would I know the difference if it's revocable or if it's irrevocable? So, Wayne, how would you answer the question to determine whether it's revocable or irrevocable?
Well, funnily enough, most commonly it's in the name. When we do the type of planning that is of the nature of estate work, in other words, probate avoidance, insurance that all of the assets that you want will be received by the people that you want them to be received by, because as we all know, we've seen tons of movies where, wills are declared invalid or beneficiaries come out of the woodwork. The planning component of what we call revocable living trust is the key part, because what it really is it is an estate planning tool. It is not an asset protection tool. Mm-hmm. And again, we'll talk about the differentiation between the two, but the visual I like to try to give my clients is that a revocable trust, and again, it's oftentimes called a family trust, or it's just named for the individual for whom the trust is being drafted. But I want you to visualize that type of trust as a net, okay? Because when you visualize trust, a net versus a box, okay? A net is a revocable living trust. A box is an irrevocable trust. And I'll get to the box in just a second. But what I want you to think about is that when you create a revocable living trust, what you want to do is you want to put a net around the outside of your assets, because during the course of your lifetime, you want to live your life the same way you did before. And the reason it's a good metaphor is a net has holes. So you can put things in and you can take them out, and you don't have to worry about having a key to the box to get them. Okay. So as you live your life, it just sort of progresses along. And then the key part from a estate planning perspective is when you do pass away, or when the second of the husband and wife pass away, if it's a family trust, the net pulls tight. And then it allows for a trustee rather than an executor / personal representative overseen by the court, and we'll get to that in just a second, to be able to make distributions from this net to the people that you want them to go to. Now, we've all heard those probate nightmare stories, right? So the key rationale for doing a revocable living trust is to avoid that. And if you place your assets in the trust, and we're going to talk a little bit about a legal term called funding in just a little bit, but the idea here is that you put this net around your stuff, you live your life, and then when you die, everything gets put in and distributed out. Now, on the opposite side of that is an irrevocable trust. Now, that's the box. So think of the box, think of a key. And so oftentimes when you're doing an irrevocable trust, you are attempting to either protect something or to remove it. In other words, to remove it from your estate or to protect it from creditors or others. So you place it into the box so it has a protective coating. And that's really the main difference.
Yeah. So when I'm having a conversation with, they say, well, I don't know if it's revocable or irrevocable. I don't remember. One of my first questions I usually ask is, well, is it tied to your Social Security number, or did you have to set up a special tax ID number where you're doing filings and you have an outside trustee that's not yourself? And they go, well, no, I put things into it, and yes, it's in my Social Security number. Well, that tells me that it's not going to work for certain types of things that they think it's going to work for, such as asset protection or allowing them to exclude assets for VA purposes or Medicaid purposes or other types of things. So if you have it in your name, or it's in your Social Security number, and you are in the power seat, would that be the good term? You're in the power seat as the trustee, then that's pretty much going to tell us that should be a revocable, the net versus the box, right?
Yes. And I'd say there's a subtlety to that is actually important here, because again, most people, when they hear the word trust, they do think of some components of protection. Mm-hmm. What I described just a few moments ago, this idea of placing a net around everything, that the benefit of that is that you can remove things as you come in, as things come and go in your life. In other words, you own a home, or you own a vacation home and you want to sell that, or you will have assets, other things that go in and out. That makes your life very easy to do. But the one thing it does not provide is if something were to occur in your life, maybe a claim made against you, or in certain cases, divorce and other things like that, those assets are not protected in the same manner as they are if you park them in an irrevocable trust. But the key thing about an irrevocable trust, and Scott kind of started with that, is that you have to give up control. And that is a major factor and a major, diminishment for a lot of folks. They don't, everybody likes to have control over their own stuff. And why not? Right. We work hard. We try to accumulate what it is that we need in our life. And then we want to try to live out our life. Why in God's name would we want to then place it into something that requires us to go and ask permission? Almost.
Yeah. So, and Wayne, we just got a question. It just popped up. Do you need a will in addition to the trust?
Well, that's a very good question, actually. And the answer is yes, but it is not the same type of will that most people commonly think of. The most common estate planning tool is the last will and testament. Okay. It's again, the one we see in all the movies, everybody does the reading and all of that. Mm-hmm. A last will and testament is something that you use as an alternative to a trust. So when you do a will rather than a trust, you state your wishes there as to how you want your estate to be distributed out. So divided among your family or whomever, charity and all the rest of that stuff. When you create a trust, though, as a fail-safe, any good estate planning attorney will add something called a pour-over will. And what the pour-over will does is it serves almost identically to what a will would do. That is, takes property and gives it to a designated beneficiary. However, the designated beneficiary in this case is the trust itself, because in the trust is the language that disposes of the assets. So you want everything to be treated as if it's in the trust. And this is actually a good segue to talk a little bit about funding, because one of the things that I often have happen to me, people will come in and come see me, and they will have done a trust, say, 15 years ago. And, and the trust is valid. It has the appropriate formalization and all the rest of that stuff. And I say to them, well, what accounts are in here? In other words, have you put anything inside of this trust, or is it just a piece of paper? And they say, oh, well, I didn't really realize I was supposed to do that. So certainly when I do a trust plan and when Scott and I do them together, we work hand in glove to ensure that all of the assets get in there, because a trust is a type of contract ultimately. And so if you don't have the items inside of it, it doesn't apply. So you want the things to be in there so that it could be distributed by that thing. And so the reason you use a pour-over will, is because if for whatever reason there is an asset that happens to get unaccounted for, in other words, it's sitting outside of the trust at the time of death, you want to be able to use the trust to still distribute it. But you have to then go through a limited process of probate. It's very much narrower than regular probate, but it will pour the asset into the trust and therefore serve as a backup or a net that kind of sits underneath the trust to ensure that all the assets get in.
Yeah. So sometimes I'll have people come to me and they'll say, well, should I have a trust? Should I just have a will? What should I do? I said, well, I'm not an attorney, but I can tell you one attribute that's very attractive about having a trust is privacy. And they go, oh, tell me. And so the privacy piece is one where if you don't want your neighbors and a bunch of people knowing like what you have, if you have just a standard, will and you pass away, those things get recorded within the local jurisdiction and it can actually be listed out there. And people could go look at that and say, oh, well, you left it to this person and you had these types of assets. That now sets that person, that beneficiary, up as a target for fraud, for scandals, for all kinds of things that could come about. It also is like, well, it's nobody's business on what assets and what money I have. And I find that there are a lot of people that are attracted to the privacy side of funding the trust and then having that flow through without it being recorded out there in the jurisdictions. That's been one of the popular reasons why people want to have a trust, especially if they're very private.
Well, I'd say with so much information, I mean, we all face this. Privacy concerns is basic. It's just the core of today's modern life, and there are very few things that you can kind of shelter from the outside world. But trust-based planning is one of those things. There are actually there's a statutory provision in the Florida law that says that if you have a trust and you need, for whatever reason, to prove that you have a trust, in other words, if you're opening a bank account, say, in the name of the trust, you do not have to provide the full trust. You only have to provide a proof that you actually have a trust. And again, most good estate planning attorneys will provide something called a certification of trust along with the trust, so that this 2-page document, which basically is a document that says, I have a trust, trust me, that's all they need.
And here's the name and here's the date. That's all they need.
And that's all they need. They don't need to know that you're giving, that you're providing for a pet trust for your wonderful German Shepherd, or that you want to give, money to your crazy aunt. None of those things are required. And as I said, in a world where everybody feels so exposed, it's kind of nice not to have your possessions be perused in such a way that, because it's not even so much that people can, with fraud and other things, but, imagine if a relatively young person gets a control of a fairly significant amount of money, so everybody and their brother is going to want to try to go and try to sell them something. So it can be very, very advantageous. And again, if all the assets are properly funded into the trust, as we talked about before, that is basically having the trust own them, none of that ever gets into the public domain, because the public aspect of death is probate. And if you can use the trust to avoid probate, which is its main tool, the main idea behind it, then you're fine. Then, that's one of the benefits.
So you start off with a trustee and then you have successor trustee. So if I'm managing my own trust, or let's say I don't even trust my own self, I want someone to be the trustee. The question just popped up. So do you have to have a trusted friend? Do you have to have somebody that you're leaning this into? How does that get typically handled? What is the most prudent way if you can't continue as trustee, or you don't have a trusted friend to do that, or you choose not to?
Well, I would, when trusteeship is discussed, and it is something that we do talk about, because in the case of a revocable living trust, it is certainly far more the rule than not that people will want to manage their own money. And again, when you have a spouse, husbands and wives or other, that the nature of the trust is it flows between the two people equally. So the trust will basically live to the death of the second of them. So if, for example, the husband dies, but the wife is still alive, nothing really changes with the trust. It's sort of like a car with two steering wheels. And when one person passes away, the other person is able to still continue to drive the trust in just the same manner that they had before. But then when you get beyond the life of what we call the grantor, the one who creates the trust, it can take a lot of different factors. And this is where trust with a large T needs trust with a small t, because you're right. You don't want to hand the responsibilities off to someone who you don't trust. And if that is not a family member, then it can often be an independent person. There are oftentimes some minimums with the size of the trust that are required to be there. But I will say too that over the course of the years, we have made it easier for people who are non-professionals to serve as trustees. We've lowered the standard by which they have, because again, if you give your money to Scott has lots of responsibilities, not only to you because you're his client, but also to all the associations and all these others that he belongs to. Okay. So he has these obligations, and banks and others are no different than that. Clearly, if you put the same type of burden onto a friend, a brother, a cousin, nobody would want to do it. Okay. They'd say, forget it. I'm out of here. And so not only do we create a slightly different standard for them to have to manage the trust, but we also give them protection that if they do things that are perhaps not within the realm of what a professional would do, that they can't get sued or anything like that to participate. So It's a very, very personal thing, and it's often the subject of a relatively lengthy conversation when we're actually building the trust to ensure that the continuity of the trust beyond the life of the maker is taken care of.
Yeah, I have found that when people don't have a good successor trustee in mind, or it's going to be too much of a strain on family members, think about it. Uncle Bob is now fighting with his nieces and nephews. That's not good. And so Uncle Bob can now defer off to a corporate trustee. So at a bank trust company, and they vary a lot. And there are some that will put provisions in there, or there's a lot of large banks that they put provisions that if you ever try to leave them, they make it nearly impossible. And they charge exit fees that are extensive and onerous. And so you want to have a conversation with somebody who's experienced in this. So before you just go say, hey, my money's at XYZ bank, I'll just do it there. That may not be the best case. And oftentimes it's not, because they may, in fact, have really rough time there. And so there are some independent trust companies, and there are some wonderful fiduciaries out there that will do a great job that's not part of the old system. I'd like to shift gears for a second here, Wayne, and jump over to irrevocable trust. And there are three major, or really 4 or 5 major irrevocable trusts that I see, that I encounter a lot. One is Medicaid trust and VA trust. Sometimes it can be the same trust that's a Medicaid and VA trust. And so if you're not familiar with VA benefits, there are benefits for people that served during a wartime period, and usually they're 65 and older, and they could be receiving substantial money. My parents have been receiving money from the VA, and in order to do that, sometimes you have to, if you have too many assets. Right now in 2022, the number is $139,000 of assets outside of your home and your car. If it exceeds that, then you're going to really need to have a trust. There's a 3-year look back for that. And so having the proper language in the trust, Wayne has done this, and we've had some seminars together. Also, Medicaid has a 5-year look back on that. And I have a friend who came to me to do some planning, and now they're wishing they had done the planning. That was a little over 3 years ago, because they're spending $22,000 a month on mom. And they never anticipated that. So they're eating through assets, and it would have been best that we would have done the planning up front. So Wayne, tell us a little bit about the Medicaid and VA trust and how that might be different than your family revocable trust.
Sure. Well, let me set a little bit of architecture here, because you use the most common uses of irrevocable trusts are to do basically one of two things. And the first one in the past was the most common. And that basically was to remove money from your estate so that it wouldn't be subject to the estate tax. Now, it hasn't been that long, 20 to 25 years, when the estate tax threshold, that is the amount of money that you had, if you had any more than that, you would be paying estate taxes at a fairly heavy bite, anywhere from 45 to 55%. A lot of people obviously did not want to pay Uncle Sam using the money that they had earned during the course of their lifetime. So when we had a $600,000 estate tax threshold, when we had a $750,000 estate tax threshold, anybody who had decent life insurance and a home, because they all get counted as part of your wealth, they were going to be subject to the estate tax. So we were parking money left and right. We were using all kinds of tools. Scott and I are going to talk about a particular one, something called an ILIT, or an insurance trust, in just a little bit. But the main thing here was that people wanted to give up money from out of their estate. And as you may recall from earlier, I said the downside of that, of course, is that you had to give up all control over it. So people were giving money to their kids, they're giving money to their ex-wives, they're giving money to anybody they could, because they prefer to give it to them rather than give it to Uncle Sam. Now, flash forward to today, the current estate tax for a couple is $26 million. Now, $26 million is a lot of money. As a matter of fact, only less than 0.5% have that much money in their estate. So for those of us that are in the business and want to stay in the business, we don't do a lot of planning for those folks anymore. But we have learned to use the very similar tools to assist us and to assist our clients in qualifying for certain types of benefits. And Scott mentioned the two most prevalent ones. The first one is VA. And with all of the people who have served during a wartime, and, interestingly, wartime doesn't mean that there's bullets going through the air. We've come to find it's actually windows of time where, as long as the service person was in service during that time, they can become eligible for an additional benefit over the top of Social Security and a pension or whatever other ways in which they're making money at retirement. But it has a qualification process. And one of those is if you do have too many assets, you can park those assets very much in the same way that we used to do it to avoid estate taxes, so that after a period of time, in the case of VA, 3 years, and in the case of Medicaid, which I'll speak about a little bit in detail after, it's 5 years. But what you do is you're basically you're giving up control over that money in order to gain a benefit. And there are certain assets, and the two most significant assets in most people's lives, their homes and their cars, which don't get counted. So it's a bit of an intricate thing that we have to do to ensure that at the end of that look back period that Scott mentioned, that we are able to qualify. But with Medicaid, clearly the hope there is that if you have need of medical services and you are borderline with regard to being able to afford them, and anybody who's been in a hospital lately knows how incredibly expensive it is, or in a living situation for older folks, that it's tremendously costly. And the government does have a program, as we all know, called Medicaid, that will take care of those folks who don't have the money to be able to assist themselves. But setting yourself up for that does require some forethought. So you have to begin the planning process before you actually need it. And so what Scott was saying earlier about the client who walked in, that happens to me all the time, where I'm literally getting a call from somebody who they're on their way to the nursing home with one of the parents. And the good thing is that generally, if we have one who's going in and one who isn't, then we can do some things. But otherwise, you have to wait it out, or you have to spend down a lot of money. So the type of planning that goes into these, it requires some, as I said, some forethought, some planning to ensure that when it is necessary, and quite honestly, those two types of trusts for VA and for Medicaid operate very similarly. Because you can basically hand over the responsibility of the money that you need to live, that the person who's going to be ultimately applying needs to live, to a loved one, to a cared one, most often their children. And so you establish a trust that's controlled by your child to basically take care of you. But you can't take care of yourself with that money. They have to take care of you with it. And then therefore you can become out.
So, Wayne, I want to tell the audience today that elder care is an event. It's not a place. So elder care can occur at your home, at another family member's home, at a assisted living, at a Medicare, Medicaid facility. I mean, it could occur different places. Yes. And people are presuming that Medicare is going to provide for long-term care. It really doesn't. There are 80 days on a lifetime basis where you're going to have rehab and substantial stuff. So when my father broke his hip and it was considered full-on skilled nursing rehab, we used up some of those 80 days. And so know that that's a lifetime. It's not a calendar year or anything like that. It's a lifetime. You're using that up. So that's important to understand. And in the picture of elder care, there are a lot of moving parts. There's a lot of governmental things that are going on. If this is an area you'd like to have a conversation, you can please reach out to me. I'm experienced at this. I can talk you through. I can quickly triage and figure out, did your parents apply or not apply? Were the dates during a wartime period? What does that mean? It's not just assets, but there's income versus medical expenses, and what are qualified medical expenses and who can be paid. A lot of other complications there. Right. Didn't mean to get off the subject, but elder care is gigantic. There's a whole generation right now that's one of the biggest concerns that they have. So I wanted to push that out there. Did you have anything else you wanted to add to the Medicare conversation?
I'll tell you that's a great thing.
Or elder care?
Yeah, to mention, because a lot of people, I think some in the media are a little bit challenged to kind of figure out where the lines are. We all hear those unfortunate stories of elder abuse and fraud as it relates to older people. And somehow a lot of people have felt that is what elder law is about. And yes, believe me, there is a need for those things. However, this is a lot like any of the type of planning that I do. This is the intersection of your possessions and those kinds of things, and then what your needs are going to be ultimately at the end of the day. And so like doing a will or doing a trust or doing a power of attorney or any of the documents that can really smooth a lot of problems down the line, it's always better to get ahead of it. If you're thinking about it, if you've read about it and you have questions, the great thing is Scott and I work, as I said earlier, we work very closely together to blend the best of both, because if there are assets that do need to be set aside, you still want those assets to work. Okay. So the availability of having a very experienced and caring investment partner is critical. But there are certain parts that Scott can't do because there are legal things that have to be done in just a certain way because they have to qualify. And so you have to dot the I's and you have to cross the T's. And that's my job. So the two of us work as a team to ensure that as you look out into the future, no matter what the needs are, we hopefully will have solutions. And of course, because we listen rather than talk, although we are talking today, that we can customize them in such a way that they fit your very specific need.
Yeah. So I want to share a universal truth, and I've learned this over the last 30 years, and it's really important. Mm-hmm. It's easier to prepare rather than to repair. Mm-hmm. So having your planning done up front that is proactive versus we've created a problem, now we got to go back and try to fix it. Partially because there's a clock ticking on some things, mm-hmm. and partially because there are certain types of assets that are better to liquidate than others. There are income tax issues. There's lots of other things that can come into play, and having an open conversation, having a dialogue about this, what I've found has been very valuable to a lot of people. And so remember, it's easier to prepare than to repair.
I like that thought a lot, Scott.
Yeah. So are we going to talk about irrevocable life insurance trust, the ILITs?
Yeah. Let's talk a little bit about those. That was, again, when we were looking in the past to not only protect money from the impact of estate taxes, but also to kind of turbocharge people's ability to gift. We have in the past and still continue to use something called what is often referred to as an ILIT, which is an irrevocable life insurance trust. So again, it falls into that bucket of steel boxes. Okay. It's got the name irrevocability right in it. And what you do when you do a life insurance trust is, assuming that you can qualify from a health perspective, what you do is you take a relatively significant sum of money that might be subject to taxation in the future, and you basically pay it as a premium to an insurance company, so that when you eventually do pass away, and oftentimes these are what we call second to die policies, because they're based on the life of both of the spouses, because the goal is to benefit the children. In other words, to amp up their inheritance at a future time in a way that helps you today, and then even more so to the children in the future. So you have a policy that basically lives with the life of the makers. And then instead of it being worth, say, $500,000 in premiums that you might pay over the course of that, it might pay out $2 or $3 million. So you're taking a chunk of money and basically you're making it into a much bigger one for the benefit of your children. And again, so long as you as you follow the rules, you do these in an appropriate way. And, one of the things about the nature of my practice is that, yes, I always want to customize it to the needs of my clients, but I don't have a blank canvas upon which to work. I have to ensure that because of whatever rules are in place, that I make sure that I meet them so that the tool that we're creating will actually work. And I never know when that's going to be. It's a little bit of a strange position for me to be in as a professional. I do my thing and I hope my clients live forever. But at the same time, I don't ever really know. But the great thing about ILITs is that they can be extremely efficient in creating a benefit today and then even amping that benefit up in the future.
So there's something called sunset. Some of you are going to find out there's a sunset provision for estate tax purposes. It will go into effect January 1 of 2026. Is that right?
Well, we think so, because again,
we think so.
We have faced these before.
Yep.
We, funnily enough, when I started my own practice, it was on the cusp of what we believed then was going to be a bonanza, because we had raised the threshold for estate taxes up. I believe it was at $3.5 million, or maybe it was $2.5 million under the Bush tax cuts. You may all recall that, when George W. Bush came into the presidency in 2001, that Congress passed a tax cut, and as part of that tax cut, they began over the period of time to raise the amount of money that you could have before you got hit with the estate tax. And so it raised over the course of those 10 years, but because it was done in reconciliation, which is a word we all now know, because if we watch the news, we know about reconciliation. It couldn't be permanent. It had to have a sunset.
Mm-hmm.
So it was due to expire in 2010, and it did. And so there was no estate tax at all in tax year 2010.
That was a good year to die if you're wealthy,
except if you're George Steinbrenner, because there was no stepped up in basis. But anyway, but interestingly, under a Democratic administration, who are, they're certainly known more for the idea of making sure that the rich pay their share, that they actually raised it. They raised it from the existing $2.5 million to $3.5 million, and they actually added some other things that benefit the wealthy. We have since then, when the Trump administration came in, it then doubled it. So that's how we've gotten up to such an enormous sum, nearly $8 million per person of exemption, which really does exempt virtually everyone except for the ultra wealthy. And so, we may, at least on paper, in 2016, because again, the Trump tax bill was passed in 2016. So in 2026, which is the 10-year anniversary, which is apparently the limit under reconciliation, it's going to go back. I think it's going to go back to 3.5 or something.
Yeah, there's supposed to be some inflation adjustment to it. Correct. So there's a whole bunch of talk about it could be 5.2, 5.3 based upon inflation. So there's a lot of complexity here. Here's what you got to realize. With the national debt going up, with this printing of money, with the things that are going on, it's more likely, most people would say taxes are more likely to go up, that thresholds are more likely to come down, that we may, in fact, not have 26 million. That number might be 5 million or doubled up at 11 million. So what's a strategy that people who are pushing up against that or a little over that? One of the strategies is doing what's called a wealth replacement trust, where you may say, I'm given a particular asset, like from my IRA or annuity or something that has a taxable event to it. I give that to charity. Okay. And I may fund a charitable trust or fund something. And then I buy some life insurance with some of that tax savings. And I buy a life insurance trust with some tax savings there, and then leave that for my heirs. So it's outside the estate, and it's 100% tax-free and income tax-free. And it's a very efficient way to do that. I did some of those back in the late 80s and early 90s. And because of those thresholds that pushed up, we haven't been doing it. But I anticipate that I'm going to be back in that game again here before the the end of this
everybody,
decade.
everybody tune back in 2015.
Well, we'll be tuned back in 2026
Well,
is what I anticipate.
Yeah. Here's the thing though. Let me put a point on that. And then also just talk about those folks when they hear millions, they kind of giggle.
Yeah.
The truth of the matter is the tax code is designed in such a way that if you have a significant amount of wealth, you can do things with it that not only help you, but also can help others through charity and other types of things. There are numerous trusts that we can create that benefit charities, that give folks tax breaks in the near term, and all of these kinds of things. But if you're sitting out there going, Wayne, that's not me. I have a couple million, maybe a couple $1 million in total assets or whatever it is. It doesn't mean that you shouldn't plan. Yes, okay, you may not be subject to the estate tax, but at the same time, everybody procrastinates in terms of getting in and making sure, because they think, oh, well, the rules of the state and intestacy rules or whatever are just going to take care of it. Don't count on that, because we all have an idea, I think, in our minds, way maybe in the back. If I die, here's how I want things to go. It shouldn't stay in the back of your mind. It should be on paper.
Yeah. So I need to go back to way back at the beginning, and all throughout this is there's this idea of control and distribution. You say, I don't want my kids to have everything when I die, and they might be 22 years old and, get taken over by a himbo or bimbo or something happen, some tragedy, they're a target. So trust can provide ways to distribute over time. And there can even be called an incentive trust, which could say, if you earn $100,000 a year, the trust is going to match you $100,000. Or if you go do social work that is beneficial to what the family values are, then we'll fund all that and then some. Or there are some really creative ways in which you can do distribution. You could perpetuate values through distribution, through incentives and these things. So a will can't do that. When you pass away, what are you going to do? You got a will. It just says, hey, Johnny gets the money and whatever happens, happens. Whereas with the trust, there can be some foresight. It's being a good steward. My company name is Stewardship Matters, and it's being a good steward now, but it's also setting up the next generation and the next generation to be better stewards by having some framework that's in place. Anything you want to add to that, Wayne?
No, I most certainly do, because you've touched on a key point, and that is that every family has its stuff. And if it was a different forum, I might use a different word. But the thing, though, is that we all know that there are those folks that are the next coming generation who are better able to handle things than others. And as Scott rightly points out, you can use a testamentary tool and you can make distributions, and you can say, okay, Joey gets 5% and this guy gets 10 or whatever. But let's say if you know already that you have somebody who spends too much money, who might get involved with the wrong people, who might take drugs or something that would make the future of the investment a little bit more dodgy. And it is a very rare day that I ever let any of my clients get out of the office without setting up very specific tools. Now, we're not creating trust fund babies here. We've all seen those movies where, there's this big hand on the top of somebody's head and you can and you can't do this. However, there's a tremendous benefit to this particular, in other words, getting ahead of this, because in the state of Florida, at least under current rules, we cannot create what's called a self-funded asset protection trust. That would be dandy, because then we could just spend all the money we wanted. We could take our earnings and we could put them in a trust. And when the man came with the bill, we would say, sorry, it's not my money. Now, interestingly, there are a handful of states where you can do that, but Florida is not one of them. What we can do, though, is we can create what's called a third-party trust. And what we do then is we create a trust for someone else, and we can put whatever rules on that trust we want. But here's the benefit. even if we allow for the beneficiary of that trust to be able to manage the money with inside of it, if they retain it in the form of a trust, it's asset protected. So what that means is, when you're giving money to your daughter and she's about to get married, and you really want that money to be your daughter's and not the new person who's coming into her life with a marriage, you don't want that to be protected. You want that to be protected from dissolution. Same thing. Look, we all see the commercials on TV. Dan Newland, John Morgan, they're knocking on your door. We want, $100,000 for that car accident that you were just in. Everybody's assets are generally available. Okay. But if you give money away, in other words, you create an inheritance to a third party, and this most common one is, of course, is your children. That money that you give them is not available to that creditor. Okay. So you get the best of all worlds. You give them guidance. In other words, you create some guardrails for them in the way in which they live their life, but they still have control over what they want to do with that money. But if somebody comes from the outside and wants it, there's a wall. The wall is there. It's just like the steel box that we talked about very early in the seminar.
Yeah. So I would love to be able to talk about charitable trust, but I think we're going to run out of time here.
Okay.
But there is another trust that we need to talk about before we close out. Very important. So in the future, I will have some charitable trusts, things like charitable leave trusts, split interest gifts, and other things that are both a income tax component, an estate tax component, an asset protection component, and then some other special features that are really fun and exciting. I'd love to share those things because there's very few people that I find are versed at that. And so I do love sharing that, but we don't have enough time to cover that today. But what I do want to cover is a very important thing called a special needs trust. And so this is an irrevocable trust that gets set up. And Wayne, would you address where a special needs trust most typically applies? I mean, it can apply to a lot of different areas, but what is most typically?
Let me just mention the thing before we leave charitable trust for a second. If those of you who are listening to us out there are charitably oriented, in other words, you would like for either during the course of your lifetime or after your lifetime to benefit a specific cause, and you would like to gain some additional benefits from that during the course of your lifetime, they are fantastic tools. And as Scott mentioned, when he kind of reeled off a few of the names, there are a number of different types. And so it is important to you choose the right type for you. But if you have a passion for a particular cause, they are excellent tools, but very, very specific to the needs of your, in other words, whatever it is you want to accomplish. Now, let me move on then to special needs trusts. Special needs trusts actually operate at two ends of life, because they have components of them that can help older people and younger people. The easier one to explain is when you have a young person with needs. Thankfully in this country, we have a system set up to assist those that, that may be challenged. And obviously the way in which they would potentially qualify for any type of assistance would be based on their particular needs and the availability of assistance to them. When there is the presence of wealth, and wealth can be, in this case, much, much lower than we think of, like big giant dollars, it can actually serve to eliminate the eligibility of that person to receive those benefits. And that's a bad outcome, because they are designed and built specifically to help them. But if someone is the beneficiary of a trust, for example, that doesn't have the appropriate limits on it, it can serve to extinguish their ability to get them. So when I do trusts, I'm often people will reach out to me specifically to design and build special needs trusts because they'll hear about them or whatever. But I even go so far in my own trusts of adding a couple of provisions into each of the trusts to anticipate that there might be a special needs child further down the line. So if I'm dealing with parents, and the parents have grandchildren, and those grandchildren are perfectly fine, we don't necessarily know what their children are going to be like, or whether there's something could be developed later in life that could show up. So it's something that's extremely worthwhile to consider, because again, everybody really deserves the benefit of the programs that are set up to help them. And the last thing you want is for them to have money coming in effect from the side that would serve to eliminate that ability.
Yeah. So when I think about special needs trust, the majority of the time I am dealing with a minor who has challenges that would allow them to qualify for some governmental benefits. Mm-hmm. And if they receive even just a little bit of money from grandma, grandpa, or whatever, it would blow things up. And yes. So by being intentional, and it's tough to actually go get the filings to get this stuff done in the first place. So you don't want to be blowing up something that was very hard to get in the first place. You had to file a lot of paperwork and prove yourself. And then all of a sudden, just because of a mistake of some dollars flowing into their account because somebody wanted to be generous, aunt, uncle, friend, whatever, yes. It can literally blow things up. And so very important that you're very intentional about it. I actually had a gentleman come into my office recently, a few $1 million. He's in his mid 80s. His wife's also the same age, and they have a child who could definitely qualify, and he's never even bothered to qualify her. She's in her 50s, and he's not in great health. She's not in great health, and the daughter's in great health where she could live a long time. But I'm concerned that there is not a will, there's not a trust, there's nothing in place, and there's no protections or any way to all those dollars he's worked to save for 80 plus years could be out the door in a heartbeat. And everything that he's planned for is not really working. And because he won't take that last step, I asked him, why are you holding back? What has held you back? And he says, I don't like talking to attorneys because I always feel like if I talk to them even for 10 minutes, they're going to charge me and it's going to be a lot of money. And he's scared. And so I gave him the name of a couple of attorneys and said, you go call these people, let them know that you're a friend of mine, and they'll talk to you for a few minutes so you can at least have a conversation. And they're not going to be billing you instantly. They want to get to know you and then make a suggestion. And then maybe you feel comfortable with them and you could take a next step. So Wayne, I'd like to open it up at that point and have you provide your contact information for the people that are on this call so that if they wanted to reach out to you and talk to you.
No, and that would be great. And I'll just follow up by saying that it would be one thing if I had, maybe practiced law for many more years in a different environment, but I basically had taken a little time away. And when I decided to come back, I wanted to work in an area where I could genuinely help people out. And so, that I'm glad that Scott started with this right from the very beginning. We listened before we get with the 2 ears and 1 mouth idea. For example, I do not charge for initial consultation. I actually have a relatively streamlined system by which I distribute a questionnaire out to any potential clients. And what that does is it not only helps me with metadata, things like addresses and children's birth dates and those kinds of things, but also makes you begin to think. And believe me, if I had a nickel for everybody that procrastinated, I wouldn't be sitting here doing webinars anymore. But I don't ask that. It's okay. Just show up when you want to. I know everybody puts this off. There's this correlation between being ready and going, but I don't buy that. But anyway, I can be reached wbbeckerlaw.com. My main office is in Winter Garden, Florida, but I do have satellite offices where I can meet clients in Altamont Springs, downtown in Orlando, as well as in South Orlando near Universal.
My office too. You've been to my office with clients.
And that's the other thing too. I'm lucky enough to work with a number of folks like Scott who invite me to work together with their clients. And so I do travel because quite honestly, sometimes the need will be so great that, I might be sitting in a nursing home or in a hospital sometimes. Mm-hmm. That's not the ideal way to do it, but it happens. But the other thing I just wanted to mention before we finish that we've obviously spoken a lot here about testamentary documents. I really always try to let folks know whenever I have a conversation with them about planning that there are a number of documents that everybody should have during their life. And they are basically 3 in number. There's a power of attorney, which is a financial document that allows for a loved one to be able to assist you in those instances where you're unable to handle your own financial needs. The second is something called a healthcare surrogate designation, oftentimes called a healthcare proxy. And basically what it allows for is if you should arrive for medical care and be unable to communicate your wishes, it allows a trusted person not only to make those decisions, but also to see protected medical data, which allows them to then make a sound decision. And then the final one has an unfortunate name because it confuses people. We talked earlier about living trust, and a living trust is a document that gives things away, but a living will is not. A living will is really the pull the plug document. It is an end of life choice. If you're on life support, do you want to be removed from life support? And again, it's a wonderful thing to be able to tell your family at the end of life, when you're unable to communicate your own wishes, what it is that you want to see happen under those circumstances. So I encourage you not only to think about your planning in terms of what you're going to do beyond your life, but also to take the moment to get those what we call living documents so that you have them in place just in case anything should happen.
Great. Telephone number, Wayne.
352-394-3109.
Good. I was just testing you. I wasn't sure if you could remember.
I know,
your
it's
number.
funny.
Everybody, we're pushing our own numbers in our phones today. Anyways, great to have you guys with us. Scott Thomas, Stewardship Matters. Reach out to me, reach out to Wayne. We'll have a conversation around this stuff. The elder care issue is gigantic, and there is a lot more questions and a lot more material to address in that space. And obviously, we couldn't cover that in the little limited amount of time that we gave it today. But reach out to us, and thank you for joining us today. And Wayne, thank you again.
Thank you all very much.